Acting Registrar, can you please commence the proceedings?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Barbados. Hearing of the appeal in CCJ Appeal BBCV number 2 of 2021 between Sandy Lane Hotel Company Limited and Juliana, Cato, Wayne Johnson, and Charmin Poyer. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, everyone.
Mr. Justice Witt.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnath Lee.
Good morning, everyone.
And Mr. Justice Barrow.
Good morning to all.
May we have the appearances, please? Thank you.
May it please you, Mr. President, Your Honors, I am Satcha Kisoon. I appear for the appellant Sandy Lane, and with me is Ms. Joya Reese.
Yes. Respondents.
If it may please the court, Edmund King, I appear for the 3 respondents, and with me is Miss Nyla Robinson.
Yes, Mr. King. Mr. Kisoon, are you ready with your submissions?
Indeed, Mr. President. With your leave then, shall I commence?
Yes.
Yes, I'm obliged. Your Honors, this appeal has one ground of appeal, though it's broken down into a number of subsets. We've obviously filed written submissions, and for our side, we intend to rely on those. What I would do is just indicate how we collate those bases together, and I'll do so in hopefully a brief manner. The sole ground, as we've set out, is that the Barbados Court of Appeal erred in law when it concluded that the magistrate's findings that the respondents in this case were wrongfully dismissed and entitled to damages were correct. So we challenged that decision. The appellant is saying that the respondents were not wrongfully dismissed since the appellant had terminated the respondents' contracts of employment in accordance with the express terms of the written contracts that existed between them. The respondents were each engaged by separate letters of employment, all of which were signed and contained express provisions stating that either party could terminate in each case for each respondent with 1 week's notice. Whereas that may seem short, and we'll come to the case law and we'll spend just a short time on that, that notice period is permissible. And in fact, our local decisions, our courts of appeal have ruled that that's perfectly permissible. Nothing in the Court of Appeal judgment speaks to that timeline. Sandy Lane had stated in their letters of termination to each respondent that the termination was being done pursuant to that very contract of employment, and they thereby gave the requisite notice that was set out in that contract of employment. The letter was clear that the operative clause on which Sandy Lane was relying was the notice provision, and that there would be 1 week's notice. Examples of the letter would appear at R279, that's of the record 279, and there is, for example, a check which demonstrates that that check was made as payment in lieu of notice. An example of that appears at R287, 284, my apologies. There is no mention in any of these letters of disciplinary proceedings. There is no reliance in the letter on any scheduled offense. And we say, and we'll explain why that's critical, for the requirement that Sandy Lane felt it was, and we say is lawfully entitled to follow for a termination. There's no reliance on that. We'll speak about the citing of matters which the respondent speaks to, the Court of Appeal addresses, which they have morphed, we say respectfully, into this being a disciplinary procedure. But we'll seek to address, Your Honors, as to why we say that wasn't the case here. And we'll get there very shortly. In relation to...
I'm following you, Mr. Kisoon, very carefully, and thank you for presenting that sort of preamble to your submissions. Just to detain you for 1 minute, if that long, would you concede that if this case was being decided on the statute law, it would be different? And if so, in 1 minute, can you just tell us how it would be different? Thank you.
I concede readily that if we were in the employment rights arena, this matter wouldn't even be before your honors because there would be issues of fairness. In fact, if I can just point the court on this in less than a minute still, I hope, though I'll explore it a little bit more. If we go to R647, page 647 of the record, Lord Justice Shaw, when he was speaking about the matter of Gunton, that case, he actually draws the very reference that Your Honor does. And he says at paragraph D through E that for myself, I do not consider the regulations were designed to deprive the council of their contractual power to determine the contract of service. And he goes on, if, however, the council exercised that right and were called upon before an industrial tribunal to justify a dismissal on some disciplinary grounds as being fair, it might be very difficult for the council to establish a dismissal was not unfair. So to answer your question, Your Honor, if this were under a dispensation of the statutory regime that actually called into play fairness, this matter would not be before Your Honors.
And this matter escaped that regime by a matter of what, a month or a year or something like that?
A miss is as good as a mile, but indeed, my lord, it dodged that particular statutory bullet, if I may use that term. Apologies if it's offensive. But yes, it definitely falls outside of the statutory regime. If we were within the statutory regime, fairness would be in play, and we would have to readily concede, if we even defended such a matter, that at that stage, the fairness would be an issue for this court. But we would not have got that far because hopefully our advice would have been different. And Sandy Lane would have definitely taken the position that you can't proceed under the statutory regime in a manner that you could at common law. And that distinction is what we wish to draw as we go through these submissions, because it is a different regime. And as unfortunate as it may be, issues of fairness and justness never arose under the common law. In fact, we don't say that Sandy Lane acted unjustly or unreasonably or unfairly. But even if we were to characterize that, that wouldn't have made this dismissal wrongful at common law. It would have been very, yeah.
I think I've diverted you long enough. Thank you very much for that response. Thank you.
I'm obliged to Your Honor for raising it. So in relation to the context in which we're going to frame that very point, and I want to say to the court that that theme is in fact the issue that we raised before Your Honors. This is wrongful dismissal, and as we'll get to later, as not that much later, but very shortly, that regime is very unique. It's very specific, unique in the sense that it has its own parameters and corners, and we can't import other considerations into that arena. It's a very well settled area of law. It needed to be changed. That's why the legislation came into play. We have no argument to say that the regime as it then existed was fair, but certainly there's been statutory intervention to prevent further ability on the part of an employer, in the case or in the position that Sandy Lane then was, from lawfully doing then what it did. It would now be perhaps unlawful, but it wasn't then, and that's the important feature. Now, in their employment contracts, the letters of exchange, the letters all made reference to the champion rules of the game and the Barbados Workers Union contract. On their dismissal, the respondents made the clear point that the appellant did not take any steps as set out in the BWU contract. That's a feature that they rely on, and we'll address again shortly. But they didn't themselves rely on the necessary steps contained within what we'll call the collective agreement, and that's a feature that we say militates against them being able to insist and enforce any rights that they say accrue to their benefit under that very contract. So to put it in the terms that hopefully aren't offensive, you can't approbate and reprobate, seek what is nice today, but ignore, what doesn't work for you. You have to look at the collective thing. As the Court of Appeal said, it's context. So
this is what puzzles me a little bit, because you are saying that they did not take the steps they could have taken under the BW's collective bargaining agreement. The question is, could they take those steps even though Sandy Lane had terminated them?
Yes. The reason I would say yes is that at that point there is a de facto termination. It happened as a matter of fact, so that we couldn't escape the fact that it had happened. They're challenging the de jure position as to whether or not Sandy Lane actually terminated lawfully or properly. So until that issue is determined, they could have either accepted the repudiation and proceeded to a case of, as they have done, wrongful dismissal, which we say they shouldn't have, or they didn't choose to accept the repudiation on the part of Sandy Lane and challenge the de facto position under the grievance procedure.
So a contract would still have been subsisting between Sandy Lane and the employees even after Sandy Lane terminated them.
Right. That's our submission, because it is a de facto termination, and until settled otherwise, it hasn't reached the concluded de jure position.
That seems to be consistent with what Shaw LJ was suggesting in Gunton.
It is, and again, Lord Justice Shaw's position, we find, as the court will no doubt know, much favor with that. His examination of the issues, in our view, crystallizes the oddity of the two scenarios running together.
But not with the majority's position, though.
The majority's position in relation to that point had a divergence, and of course there are factual distinguishing features which we will raise when we discuss Gunton. But in fact, I think it's an opportune time to raise it now. In that case, when the majority held as they did, they were looking at what had actually happened in the facts of Gunton. And in Gunton, the secretary for the council had invoked the disciplinary procedures to terminate. And they found that because the secretary of the council had done so, that it necessarily put them in the waters of the disciplinary procedures. They weren't allowed to backpedal or come out of it. The difference here with Sandy Lane is Sandy Lane did not make reference to any offenses, to any disciplinary proceedings, and so Gunton is distinguished on the facts alone, though the majority, yes, did consider the view that Your Honor put forward. So that's one feature. Naturally, I would offer as well that the issue of Gunton is, frankly, somewhat obiter. Lord Justice Shaw, in his judgment as well, commented that the issue of the appeal being on the basis of the procedures was not what was before the Court of Appeal at that point. And he made the point that not being under appeal, they still went on to discussion, was not, we would say, material to the assessment here. All of that which followed would necessarily then be obiter. So in those circumstances, even though there is a majority that speaks to it, all three decisions are obiter, and we seek to persuade this court that Lord Justice Shaw's obiter view is highly persuasive, and in fact logically sound, given the oddity that existed. And why we say that as well is that the fact that there is this contractual entitlement that Sandy Lane was injected with, without the necessary, and we say it from now when we approach it, fetter imposed by the other avenue, then there was no lawful impropriety on the part of Sandy Lane. They did what they should have under the contract. So that's where the oddity and the grotesque result that Lord Justice Shaw spoke on, we say, is highly persuasive, and we would commend that judgment to Your Honors. So in this case,
have you looked at the history of the Gunton case? Because if you're inviting us to take one of the two views that were expressed, you say obiter, would we not be well served if we saw how those views were treated in cases subsequent to Gunton?
Yes, it would be helpful, but as I say, these facts are different from Gunton. So the analysis in our view, would be based on the extreme fact difference. In Gunton, if it was on all fours, and we suggested it isn't at all, then the analysis, I think, would be more helpful. I'm not saying it isn't helpful, but in relation to the facts being so materially different, then the analysis may not serve the court that well, because our starting point is there's a distinguishing feature on the facts. And from our submission, the story ends there. Yeah. So in relation to the proceeding there.
Yes, thank you. I'm sorry to disturb you, but
No.
I thought in as much as you want this issue, I could raise something that a factual situation that happened that I saw reflected in the respondent submissions at paragraph 6. I don't know if you have that at hand, but they do indicate, and I will read it, I'm sure you'll find it in the meantime. Prior to receiving the letters, I take it this is agreed factually between you all. Each respondent was called into a meeting with the human resources manager and informed that they had failed to provide adequate service to a mystery shopper. Each respondent denied the allegation. None of the respondents was given a disciplinary hearing. None of them had received a previous warning. I just wondered whether this was by any chance in the nature of the commencement of some sort of disciplinary matter that was being raised.
Right, yeah.
First, of course, one would expect it to come from the human resource unit.
Yes.
Of any organization. So I just wondered, how would you want us to consider that in the line of what you say about distinguishing Gunton and the case before us? Thank you.
I'm obliged, Your Honor. If we look at the evidence of Winifred Williams, which actually sets out the purpose of the letter, that appears at R256. Ms. Williams gives evidence, and what she says in relation to that meeting, she was the human resource manager, and to put it in the context, her evidence canvasses how that letter came to be issued. The meeting, if we call it meeting with the other personnel, was not a disciplinary meeting. It didn't have the quality. It was an ante-room discussion because Ms. Williams had already prepared these letters. In fact, that comes out from the respondent's own evidence that they appeared at this meeting and they were handed a letter of termination. So there is no examination, there's no exchange to find out, did you do this or you didn't or you did, and then make a decision. As the respondents themselves say, and as Ms. Williams for Sandy Lane says, this was, if you wish to call it, a done deal. She had reviewed the contractual documents, formed a view as to how to make a termination that was lawful, and effectively prepared it prior to them coming to the meeting. So the discussions are, if we want to put it in terms that probably make more sense, a discussion as to the reason that this termination is happening as opposed to a process leading to the letter of termination. I trust, anything further on that point, Your Honor? I can.
I would like to follow up. Sorry, go ahead.
No, President, please go ahead.
If someone asks Sandy Lane, why were these 3 people terminated? What would be the answer?
They were no longer satisfied with the service that had been offered, that the fact that the ratings had been reduced as a result of whatever interaction with the mystery shopper, that is called, the Richie personnel, that they did not feel that these folks were a happy part of the continued Sandy Lane circumstance.
And they were denying that allegation.
They were, but Sandy Lane didn't rely on the allegation to justify a decision.
No. We're going too far now. Let's take one step at a time.
Certainly.
You truthfully answered me, correctly answered me, accurately answered me, that the reason these people were dismissed was that Sandy Lane was dissatisfied with their performance in relation to the mystery shopper.
Yes.
And they denied the allegation that they had been guilty of any substandard conduct.
That's true.
But they never had any opportunity to be able to persuade Sandy Lane. They weren't afforded any opportunity.
No.
And they weren't afforded any opportunity because no disciplinary process was triggered.
That's correct, Your Honor.
Instead, Sandy Lane simply relied on the 1 week provision.
That's correct.
So that in effect, with a notice period that is as lax as 1 week, Sandy Lane and any other employer has no incentive to give to any of their workers any natural justice. They simply revert to what is in the contract about a week's notice.
That is a fact, Your Honor. We agree with that. And in response to Justice Anderson, we accept that under a different regime where fairness comes into play and natural justice being what it was or is under the unfair dismissal law, there would be a different result.
So the week's notice is actually a very colorable device for evading the procedures for wrongful dismissal.
Avoiding.
You say avoiding, I say for evading, but 6 of one, half dozen of the other.
Yeah, I'm more attracted to avoid because evasion.
I really appreciate your candor, Mr. Kissoon. So it boils down to how does the law treat with that whole issue of the avoidance or evasion, whichever word you want to use, of that process. And you say that the law is that, well, an employer is simply entitled to do so because that is what the contract says. And Parliament has every right to clear up that situation, as it has done.
As it has done.
In this case, it didn't do so. That's your case.
Yes, it didn't do so in time for these respondents to have a sustainable claim for wrongful dismissal. So the timing is what we say goes against the respondents having a case. And in fact, the way that it was pleaded in the Magistrate's Court lends support to that, because not that the Magistrate's Court's pleadings we appreciate, but what the reliance in the Magistrate's Court was on some express term that the respondents would not be terminated except for just cause. And of course, we've already canvassed in our written submissions that there was no such express term. However, our view is that terminology comes from the unfair dismissal regime. And that's what would happen under the current dispensation of the Employment Rights Act, that there would be an express provision, though not in the contract, but at law, to say that you wouldn't be terminated except for just cause. But that's certainly not what pertained in the common law. And it is unfortunate. We make no excuses for it other than Sandy Lane was not acting unlawfully. It may appear unjust. In fact, we accept that, and I mean, we can look at it from that perspective. But as the cases say, wrongful dismissal is not about injustice or unfairness. It is about whether or not the employer did what they were contractually obliged or permitted to do, and that position in relation to the fairness issue is in Wallace and United Grain Growers, which we had put in our submissions, essentially, and the court uses the quotes, wrongful dismissal actions are not concerned with the wrongness or rightness of the dismissal itself, and it only arises if the employer breaches the contract. But how? In this very specific way, by failing to give the dismissed employee reasonable notice of termination. So not just breach, but breach in a particular manner.
Is there? Can you tell me what page is the letter of termination?
Yes, it is at, crave your indulgence, it is at, one of the examples appears at R279. This is the one to Ms. Cato, the first respondent.
Yes, but you see, the letter does two things. The letter references the 1 week, and then the letter goes on in quite some detail.
It does.
To reference substandard behavior.
The area of discontent. Yes, we agree. We agree with Your Honor. That is inescapable.
So it wasn't a letter that said, "There, John, according to the terms of our contract, we give you 1 week's notice to termination. Thank you for your service." It was a letter which says you didn't do that, you didn't smile, you had your back towards the guests, you had passive demeanor, and so on. Don't you think that a letter of that nature is one which suggests that essentially Ms. Cato was being terminated, not pursuant to this 1 week notice, but because she did these things?
So the underlying reason is because she did these things, and we accept that. But as we said in the court below, and it's a strange analogy, but if the employer had decided one day and their own reason was they didn't like the employee's pink shoelaces, at the time they could have just issued a letter, even though that were the reason. And let us even assume for a moment that an employer was ludicrous enough to put that in. It wouldn't, under the common law regime, make a difference, because citing the reason doesn't detract from the lawful right to do it. And just on that point, again, Lord Justice Shaw at page 647 of the record, he says when you have those two those two parallel rivers, he says, how did this code of dismissal for breaches of discipline, how are they to be reconciled with express provision for the termination of the plaintiff's contract of service by 1 month's notice? A possible solution is that the code extends or varies that express provision where other circumstances of the contract of service may be determined by reference to the express provision. This, however, and this is where we find the attractive statement, would produce a grotesque result, for it would mean that the council could, without assigning any reason, terminate the plaintiff's employment by a month's notice, but could not, if they complained of misconduct on his part, determine that employment save for what might be and prove a long protracted process. And so he goes on to make the analysis, and he forms the conclusion that one doesn't affect the other. And of course, as we say, we commend that dissenting on that feature to your lordship for consideration under a common law regime specifically. Lord Justice Shaw.
So, Mr. Kissoon, before you move on from that point, may I ask you?
Yes, my lord.
I saw how attractive the expression grotesque was to you, both in your oral presentation and in your written presentation. But is it really grotesque? Because the essence, as I understand it, of the decision of the others was, well, listen, if you embark on the road of termination for disciplinary reasons, then you are bound to follow where that road takes you. You cannot jump off that road.
That's true.
Or having failed to properly comply with the procedural requirements, you cannot turn around and say, but listen, in any case, I could have terminated without notice, with 1 month's notice, and therefore, having given 1 month's notice, that is the end of it.
Yes, I agree with Your Honor that when one follows that argument, and I'll just start at the beginning of Your Honor's argument, once you embark on the disciplinary process, then you are committed to it because you've chosen which river you decided to canoe in. In this case, the mere citation in a letter of a reason does not equate with paddling your canoe in the procedural process by starting the disciplinary process as was done in Gunton.
I imagine if you wanted to be expansive, you would even say it was a courtesy on the part of Sandilands.
That's precisely what
my underlying reasons are, but I will not go down that river or road in these circumstances. Okay, thank you.
It would guard against the potential to say, for obvious reasons, that the mere citation or narrative as to the why would have now painted them with a procedure. We say that the citation of the reason doesn't do so. Mere explanation as a courtesy, and we agree with your honors, that is essentially what it is, to explain to an employee, why are you terminating me? Yes, you have the contractual right, but here what? Tell me why, please. And in so doing, that doesn't negate, take away, or detract from the lawful right to have done what they did. And it doesn't saddle them with the liability of now saying, because you've opened your mouth and explained, haha, you now are in the disciplinary process. In the Gunton case, that process was triggered by the secretary himself on behalf of the council when he says, we are invoking the disciplinary procedures, but then the council backpedals. Of course, that's not what happened here, which is why we forcefully, hopefully.
Well, Mr. Kisun, in Gunton, it was not quite a backpedaling because the employee appealed against the decision to recommend, and there was in fact a hearing or two hearings before an appeal committee. So there was a full-fledged disciplinary procedure followed, even though, as the decision went, the fullness of the procedure was not adhered to.
That's right. No, not full compliance as the court held. But the arguments of counsel, I perhaps pushed them, but I don't agree with them, that the council was then entitled to come out of that and rely on the other position, which is in line with Shaw. But I take completely your honor's point. It's not quite backpedaling. There was a fullness of the procedure. But in this case, there was not even a commencement. We didn't embark, to adopt your honor's language, we didn't embark on that process. And the mere citation and referral by way of a reason, if one wishes to justify why they triggered the contractual mechanism, doesn't saddle Sandy Lane, we submit, with the liability of having to go through the disciplinary procedure. And that was in relation, Your Honor, to the letter that the court had asked to focus on. I don't know if, Mr. President, there's anything else on that letter, or if I can proceed with the.
I'm sorry you're calling me, because the judgment of the majority, Justice Buckley's judgment, did not appear to rely on the fact that the council had embarked on a disciplinary process as much as in the letter for termination. And I quote his exact words, it purported to relate the plaintiff's dismissal to disciplinary matters.
Yes.
It was on Mr. Mitchell, as I understood his argument, submitted that circumstance was not significant. The plaintiff received 1 month's notice, which was all that he was entitled to insist upon. As I have already indicated, I feel unable to accept that view, because in my opinion, the effect of the incorporation in the contract of disciplinary regulations was to entitle the plaintiff not to be dismissed on the disciplinary grounds until the disciplinary procedures prescribed by the regulations had been carried out. So that you have confined your distinction as between Gunton and the current case on the fact that disciplinary proceedings had actually been embarked upon. But that is not what attracted the lead judgment in the majority. What attracted the lead judgment in the majority was that, as here, the letter of termination clearly linked the termination to disciplinary grounds without a disciplinary hearing.
If Your Honor could direct me to that extract, because I heard as the court read, and there's a feature in there that I'd like to address on, but if the court would just direct me to the paragraph of the judgment.
Yes, give me a second.
470 letter D.
I'm obliged, Your Honor.
Sorry, of the internal page number,
Yeah,
page 661 of our record.
Yeah. I feel unable to accept that view because the effect of the incorporation of the disciplinary regulations was to entitle not to be dismissed
No, start from a little above. In the present case, in my view,
the counsel could have determined the plaintiffs without assigning any reason or for any given reason other than a disciplinary reason. They did not do so. It is common ground that the latter purported to relate the plaintiff's dismissal to disciplinary matters. As already the plaintiff received 1 month's notice, as I already indicated the view, because in my opinion, the effect of the incorporation of the disciplinary regulations was to entitle the plaintiff not to be dismissed on disciplinary grounds until the disciplinary procedures had been carried out. So I take Your Honor's point, but the court is reading the letter, and in the letter, it actually specifically says that it is relying on the language used here. One moment, I just turned the page. Disciplinary regulations. What that letter did was to rely and invoke the disciplinary regulations. So whereas yes, quite so, Mr. President, I'm distinguishing on that feature. The case itself and that judgment itself relies to the disciplinary procedures that were invoked by the counsel. So it is again distinguishable because that letter is what invited that. This letter from the counsel actually speaks to discipline and the procedures. In fact, the court, and I think Your Honor had mentioned that earlier. Yes, it's at internal page 458, which is 648 of the record. It starts from the page over, but on A, it says, as you will be aware, the appointment of registrar is subject to such conditions as the council may determine, and in this connection, the council's regulations as to staff discipline, including dismissal, etc., apply. Accordingly, I enclose a copy of these regulations and draw your attention. So the letter goes very, very much further, and it actually cites specifically what the regulations are for dismissal and purport to rely on that to enable the dismissal, because it is specifically saying within the letter and the content of the letter itself that this is a disciplinary matter. So that is, again, the distinguishing feature. So even though I take Your Honor's point that Lord Justice Buckley says, as the court properly says he does, it is not out of context. The context starts with the counsel itself directing itself that it is a disciplinary matter, and that's what allows the court, in our view, to flavor the dismissal with discipline. But that's different in the case of Sandy Lane, because they don't rely on any offense. They don't rely on a procedure. They merely cite, we don't like what you did. But that doesn't equate with a reliance, as in Gunton, on a disciplinary procedure on the basis of disciplinary wrong or anything less than what Sandy Lane would have preferred.
Mr. Kissoon, I suggest or I assume that it's always problematic to analyze an area of law that does not pretend to be just.
It's certainly not an easy task for any counsel to support and do anything less than vilify an unjust dispensation. But that is what the law is. So unfortunately, I'm bound to explain what the law was, and as unjust as it may be, I quote again from Wallace, the court is not to concern itself and the wrongness and rightness of the termination, it's whether or not the termination was lawful. So whereas it is a difficult battle, the courts have already, fortunately for me, done that.
Yes, of course, you can have a difference of opinion on that, but philosophically, that there is some discussion possible about that starting point. Several of us have reasoned, for example, that any law will have to be looked at from the perspective also of constitutional values, whether common law as it has grown can really be maintained under a constitution which promotes the rule of law and that kind of thing. So anyway, that will take us out of this particular case, but just to say that different opinions are possible about this kind of philosophical subject.
Yeah, I'm obliged to, Your Honor, and quite rightly, it is definitely an unenviable task to justify what may seem unjust, but as I say, I have supported the authorities on that. Wallace and United Grain Growers. We also have cited the local cases, and I won't spend much time on them. I'll just highlight them or re-highlight them. June Clark and Alico, which says that the law will hold the parties to the terms. Caribbean Commercial Bank and Ingrid Daniel, that dealt with a very short notice period, which we looking on would call perhaps unjust, but Chief Justice Williams, who ruled in that case, made the point that the court had no power to rewrite. So justness, if we use that term, there was not the issue at play, it was lawfulness. And
I assume that was then independent Barbados, was it?
It was independent Barbados.
Okay. I wanted to, because I think we understand the point you're making, and I think we see the authorities you have cited for it. I wanted to sort of just go off with a little bit of a tangent. The champion rules of the game. You were exchanging with my colleagues on the issue of disciplinary procedures, but is there also a procedure to do with performance standards, and where it is thought that an employee is not performing well, to arrange for advice, for training, evaluation, and so on? Is there that kind of procedure that's implicit in the champion rules of the game?
It is. It definitely is something that Sandy Lane could have done. They're not limited in any way. They don't have the fetter, for example, that the Court of Appeal finds existed. We say, in fact, that Sandy Lane was not in any way limited, even by the champion rules of the game. And I'll just take the court the part in the record. If the court will just create, I just create the court's indulgence for just a moment, because there is the extract from. I'm going to go to the actual rules of the game in just one moment. In the rules of the game, what it actually says is that Sandy Lane, in its own discretion, can essentially make a judgment call on the merits of each case. So yeah. If reliance is placed on the disciplinary code, then the reality that we'd be confronted with is that it doesn't, in fact, impose a threshold on Sandy Lane. So reliance on that is still watered down by Sandy Lane's inherent reserved right to treat with matters in the way that they see fit.
I follow you. How does that, if at all, comports with the contra preferentum rule? Because you have a situation where, on the one hand, Sandy Lane can part company with the employee by giving 1 week's notice, and that is what is the position of Sandy Lane here. On the other hand, you have other procedures which have to be observed in order for Sandy Lane to properly part company with the employee, perhaps a disciplinary procedure, perhaps a procedure aimed at performance on the job. So there are different ways of legitimately parting company with the employee. If there is uncertainty about which way is appropriate or permissible, do we not construe against the author of the contract or the dominant partner in this contract, in this case, Sandy Lane?
That would be the typical approach, and I agree. And just and I'll directly answer the court's question. It's just that in the meantime, I've actually found the reference. It's R313, which, and I'll just read aloud. The schedule will generally be followed, but the company reserves the right to deal with infractions of company rules on the merit. So the principle that the court raises and the question posed is, are we not bound then, because Sandy Lane wrote this, to follow the internal mechanisms? But the important, and in our view, overriding issue would be the merit of each case. And where the schedule says that, or rather the rules say that the schedule will be generally followed, that general is overridden where there's a merit that's specifically referenced. And in this case, even though, as we say, the reason that was set out in the letter was, and we acknowledge it was no more than a courtesy, that reason is something that the court can look at to see the merit, even though we say under the wrongful dismissal regime, that's not something that a court is called upon to do. There was a ranking problem for this hotel on the basis of what they got reports on from these employees. So when we look at the general following, but we look at the merit, this is one of the leading hotels of the world whose ranking has been reduced in relation to these three employees, and therefore the merit in Sandy Lane's view is reached. But in our view, this isn't a threshold argument.
I have to stop you, because you talked a little while ago about approbating and reprobating. Sandy Lane can't eat his cake and have it too. You can't set up your own allegations as matters of fact when you have issued a process that will interrogate those allegations to see whether they are in fact factual. So yeah, to me, I have a difficulty in Sandy Lane saying that, well, we also can rely on these things because these things occurred. We don't know if these things occurred. These are allegations that these things occurred. But it is Sandy Lane itself who chose not to pursue a process that can establish the fact of these things having occurred.
Which was lawfully permissible for them. And the authority seemed to support that. So I take the court's point.
That is fine. So you can say that it is permissible for them to just give a week's notice. What one cannot say is that, well, that week's notice is also buttressed by these things, A, B, C, D, and E, because A, B, C, D, and E are not facts. They are allegations made by Sandy Lane.
If we had embarked on the disciplinary process and those facts as alleged were accepted in the disciplinary process without testing, then, Your Honor, I would be forced to agree with you that Sandy Lane couldn't do that. But the recitation of those facts was superfluous to the already chosen termination process. So if they said nothing,
we'll tell you the recitation of those allegations.
Allegations, my apologies, Your Honor, quite right. Those allegations, they extended to a reason on the part of Sandy Lane as to why it triggered its contractual.
No, this is the point. You can't use as a reason your own allegations. This is why you have to either say, I am terminating you by 1 week's notice as per our contract. But the moment you go on to dredge up your own allegations, whether partially or gratuitously, in support of your actions in terminating the person, then you have opened the door to a problem.
On the face of it, I would agree, Your Honor, but the reason I respectfully disagree with that is that the add-on comes after you've done your contract, you've exercised your contractual right. So ex post facto giving a reason doesn't mean that you've committed to the disciplinary process. For example, in Gunton, you've put a reason out there which is not favorable or leaves a very bitter taste, and I accept that it does that. But if they said nothing it would not have changed their contractual right. By saying something after they've exercised their contractual right doesn't then put them backwards in time to say, aha, well, you have to know, or you should have gone through the disciplinary process. You're giving an ex post facto explanation.
Yeah, but when you do that, it has consequences for the worker, because the next place the worker applies for a job will be told, well, we dismissed him because he didn't do any of these things. And here is the letter to establish it. But those things have never been established.
But in fairness, Your Honor, if someone were to, we were speaking in general terms, apply without a reason being put on the dismissal letter to Sandy Lane would have been at liberty to raise those allegations even though untested, and that wouldn't have changed the fact that Sandy Lane was entitled, well, I don't want to use the word entitled, could have stated things that were untested as a reason given to a third party inquiring, even if they didn't put it in the letter. I don't think any employee is going to take that letter and hand it to a prospective employer. In any event, again, they would be able to explain that there were allegations as they were, and we accept that. But that doesn't take away, in our view, the contractual right of avoiding something that they may have otherwise had to embark on. And as the court has said here, I mean, that would go through a process. And what is the result? The result is that they would have had an opportunity to be heard and ventilated. But in this case, as the court has seen from the evidence, Sandy Lane had already made its decision, and they were entitled to make that decision, not under the current regime. They couldn't make that decision under the current dispensation. That would be unlawful because it would be an unfair dismissal. But they could have made it under that dispensation, as distasteful as it may appear. Again, Wallace and United Kingdom, it is where the court in these circumstances is not concerned with the wrongness or rightness of the decision. It is the lawfulness. We accept that on the face of this. I don't think that we can run from that. It appears distasteful. Yes, that is something that I think employers probably find themselves confronted with many times. But if it is lawful, then that is an issue that should not trouble the court.
So the limits then to which would sort of hem in an employer would, in terms of commenting on the reason for dismissal, would be constituted by what? The law of defamation or those kinds of rules, is it?
Sorry, Your Honor, forgive, I didn't quite hear the beginning of the question.
No, I'm just wondering, you're saying that Sandy Lane basically is free to say why it terminated these employees. It might have been related to the color of their shoelaces, or it might have been related to allegations about lack of adequate performance. And I'm asking you then, are there no limits? I suppose the only limits would be those constituted by the law of defamation or...
Yes,
or
I agree. And to whom it was published, the manner and so on, and whether or not it was factually true, and the onus would then fall on Sandy Lane to show and demonstrate that it was. But naturally, in relation to whether or not it was a wrongful dismissal, we don't get that far.
I understand. Now, just to clear up my question I asked you about the contra preferentum rule, I gather you're saying yes, in theory it could apply, but it is ameliorated through the terms inserted in this particular contract. In effect, is that what you're saying?
Yes, those are the submissions I adopt, indeed, Your Honor, to justify that.
Okay.
Yeah. To be frank, Your Honors have canvassed a significant number of the issues that I would have posed with the court, and I wouldn't seek to detain the court, and we're close on the hour time. All I would offer, and I mentioned in the submissions, and I will not gloss them over, but just speak to them, that the only reason that the Court of Appeal found that Sandy Lane had wrongfully dismissed was this fetter that we spoke about earlier, and that based on the fetter, and we've argued in the written submissions and somewhat here why we say that fetter didn't exist, but the fetter has to lead to something. There's an inherent acceptance in the Court of Appeal's decision that there is a right to terminate in the way that they did, but it is fettered. And I want to just go back on that for a minute, because if it was that there was no fetter, then the decision of the Court of Appeal must fall away. There's no wrongful dismissal. But I go further. If there was a fetter, the Court of Appeal has ruled that there is a wrongful dismissal. And we've spent some time discussing what a wrongful dismissal actually is. And I want to make the point that in this case, notice was given. Payment in lieu, rather, of notice was given. And we make that point because the case law, it seems to us quite clear that wrongful dismissal is a very specific term. Chief Justice Simmons in June Clark and Alico made the point that wrongful dismissal is a product of the common law. It is not the same as a breach of contract. And that's why I want to make the point that even if the Court of Appeal was correct that this fetter existed, and we spent some time discussing that fetter, would a termination on the basis of that fetter or in breach of that fetter equate with a wrongful dismissal? And the answer, we say, is no, because it is not a wrongful dismissal. It may well be a claim for breach of contract and the damages that would associate itself with that. But wrongful dismissal is a very specific term. And in this case, it doesn't arise because wrongful dismissal is when there is termination in the absence of notice or payment in lieu of notice. And in this case, whether we agree that there was a right to do so or not, that is what happened. And therefore, the cause of action as a claim wrongful dismissal is not the correct claim. And as such, even with the fetter, at worst case, if Sandy Lane was in breach, they're not liable for wrongful dismissal. And we spent some time in the written submissions canvassing why we say so, and that appears at paragraphs 11 to 21 of Sandy Lane submissions, and that appears at the record at pages 395 to 400, where we examine the meaning of wrongful dismissal under the common law and explain why this could not have been a wrongful dismissal. And I can certainly go through that, but I hope that the submissions in that regard and the written submissions canvass the issue as appropriately as can. I'll ask Your Honours to review that. The upshot of that is this is not a case of wrongful dismissal, even if the Court of Appeal was correct in saying there was a fetter. So even if it
was framed, I'm sorry, Mr. Kissoon, but if it was framed as a breach of contract case, as you're suggesting, it could have been from their point of view, the other side's point of view. What would the difference be in terms of, for example, damages?
The damages under the wrongful dismissal regime are set out in Barbados under Section 45 of the Severance Payments Act. So the damages are a quantifiable amount that's prescribed by statute, in the sense that there is a quantification you can go to. If the damages were for breach of contract, what the respondents would have had to have done was to examine the amount of time to which they would have either been lost wages, or they would have otherwise suffered some contractual breach, which I couldn't pretend to know what it is. But in the normal wrongful dismissal regime, it would have been the amount of time that you didn't get the notice for that you were contractually bound to give, which is why we say it can't be wrongful dismissal, because they did give that notice. And the measure of damages would have been circumscribed in the written agreement, which was triggered. If there was a wrongful dismissal, the measure of damages now goes to Section 45.
Okay, and I know I'm asking you a bad question, but I'll ask it anyway. Under what regime would the damages likely be more? Under the breach of contract regime or under the wrongful dismissal regime?
The wrongful dismissal regime.
It would be likely be more. Yeah.
It would definitely be more.
Yeah. Okay. Which is why we're here.
Mr. Kissoon, you would say not just definitively, but significantly more, wouldn't it?
Significantly more under the wrongful, if there was a wrongful dismissal, which we say couldn't exist based on what the definition of wrongful dismissal actually is.
Got you.
Your Honours, to be frank, looking at my notes, I believe that I've canvassed much of what's in our written submissions and hope to engage with the court on, and I have no other specific points to raise. And if there are no other questions, and then with your, those will be the submissions for the appellant. unless there are any other questions.
Yes, that was on. Thank you very much, Mr.
Right.
Mr. King, are you ready? You're on mute, Mr. King.
Oh, I'm sorry about that. If it may please the court, I was glad to hear my learned friend state that if the current regime in relation to unfair dismissals was in force at the time, we would not be here today. And my submission, Your Honor, is that this is precisely why the Barbados Workers Union and the Employers Confederation, of which the appellant is a member, had negotiated an agreement between them to introduce an element of fairness in the employment regime. And it is a situation in which the negotiated situation is almost on par with the current legislation at this point in time. Now, it is common ground that there was incorporated in the contract of employment a disciplinary code, that is regulations as to staff discipline. And this is contained in the champion rules of the game, which prescribe the procedure to be followed in regard to dismissal of a staff member for breach of discipline. That code, the champion rules of the game, set out in page 12 of the record, 312, I beg your pardon. And it particularly sets out to which I want to draw your attention at page 314 of the record. Poor standard of work. This is one of the offenses set out in the disciplinary code, and it gives for the first offense verbal warning, second offense written warning, and the third offense dismissal. Now, in the letter of dismissal handed to each respondent on that fateful day of January the 30th, 2012, each alleged poor standard of work. Now, this brings it fully within this section of the rules of the game. And it is expressly stated at page 318 of the record. Page 318.
Page what?
Yes, my honor. Yes, my honor. Under disciplinary procedure as per collective agreement. If you go down to 1, 2, 3, 4, No case involving disciplinary action shall be brought against an employee until the above steps have been taken, except in instances which warrant summary dismissal. And it goes on at 5. Any disciplinary action taken without following the above procedures shall be set aside. Now, once we agree on, from day one, before the magistrate, my learned friend had accepted that the champion rules of the game were part of the contract. There wasn't any dispute at all about that. The magistrate found otherwise, but between both of us, we agreed that the champion rules of the game were part of the contract. The Court of Appeal also found that it was indeed part of the contract. So this element of fairness was specifically introduced by the agreement, the employment agreement.
Yeah, Mr. King, I think Mr. Kassoon agrees with you that the champion rules are part of the contract. I don't think he disagrees. In fact, I think I saw him nodding as you were speaking. But what I think he's saying is that those rules give some wide margin of discretion, to borrow a phrase from elsewhere, to Sandilands. And then you were quoting just now from what constitutes fairness and justice.
Yes.
I'm not sure you referred to the context in which Sandilands apparently has the discretion vis-a-vis particular cases.
A discretion, Your Honor. I believe that my learned friend had taken that quote out of context. And I believe he was referring to page 313 of the record. And if one looks at disciplinary code there, the company requires a good standard of discipline from you, together with satisfactory standards of work. Code of discipline rules apply to all employees of the company. You will be dismissed if your standard of work or conduct falls and after warning remains below the level which is acceptable. The following are examples of misconduct or poor performance for which you can be disciplined. For acts of gross misconduct, the company reserves the right of summary dismissal. Abusive language is not permitted. The list of matters liable to lead to disciplinary action or summary dismissal is not exhaustive, as it is not practical to specify all offences. The schedule will be generally followed, but the company reserves the right to deal with infractions of company rules and regulations as the merit of each case. What I understand that to say, Your Honor, is that, okay, we have listed offences, we have listed the penalties, but these are not exhaustive. We reserve the right to add, or even to subtract for that matter, any of the items that appear here. But generally speaking, what they're saying is, listen, you need to be guided by what is stated here. And the employees themselves is what the position would be.
Is it that you're saying that if a particular offense is specified, then this provision is excluded, that once it is specified, it should be dealt with according to the manner in which it is expressly set up. It should be dealt with.
Yes, Your Honor, that's my content.
Mr. King.
Once it is specified.
Mr. King.
Yeah.
Mr. King, yeah. Question. If Sandy Lane had not mentioned the reasons why they thought the employees had to be dismissed, if they just had said, well, we refer to the contract and we give you notice, 1 week notice, without mentioning any reason, would that have, would you still have a case?
You were falling out somewhat. I didn't get the full comment.
Okay, so let me try again. If Sandy Lane had not mentioned the reasons that they put in these letters, but if they just had said, well, we, for reasons, certain reasons, referring to the contract, we will give you notice for a week notice. So not mentioning the reasons, would you still have a case?
I think so, my lord. If one accepts that the union agreement is part and parcel of the contract, then when one looks at the union agreement, and I'm looking at page 344 of the record. And it says right at the bottom, part 25, termination of employment. The employer shall have the right to discharge workers for established and proven instances such as, but not necessarily limited to, dishonesty, discourtesy to a guest, justified complaints by a guest, and so on. I am submitting that even if the reasons for dismissal were not stated, and Sandy Lane just took it upon themselves to terminate the employee, that they would still have been entitled to a hearing. If we accept that, the workers' union contract with the Employers' Confederation was incorporated in the contract of employment of the employees.
Are you then saying that the letter of termination should always mention reasons?
I am saying that, Your Honor.
So, if they don't have to mention the reasons, should it then be obvious somehow that the termination was based on certain allegations, even if they don't mean? Because the contract has a clear part which says the contract can always be terminated with notice. So does it mean then that part cannot be invoked?
No, because you have agreed to a specific procedure, termination.
Sorry, could you repeat? Could you repeat? I didn't catch that.
I'm so sorry.
Would you repeat? I did not catch what you said just now. Your last sentence.
That the contract between the employer and the employee had set out a specific procedure to be followed if you're going to be dismissed. And that procedure is set out in the champion rule of the game.
Sorry, Mr. King, are you saying that there can be no termination? There can be no termination simply as a matter of acting on a decision to terminate without any just cause?
Yes, Your Honor, that's what I'm saying.
What take me to the termination provision in the contract, please. Take me to the termination provision in the contract. But for notice, termination with notice or upon notice.
Could you remind us of the page, Mr. King?
I'm so sorry?
Could you remind us of the page that you're going to?
I'm looking for at this point in time. I was asked to point out in the contract the provisions for termination with notice. So that's where I was looking for it here.
Right.
PG contracts.
Page 277, if I may.
Yes, 277. Yes, 277. That's right. Yeah. Termination of employment. During the first 3 months of employment, the hotel may terminate your services without prior notice. Therefore, except where summary dismissal is justified, would you be found guilty of misconduct or dishonesty at work? The period of notice, except for cases of redundancy, required to be given by either party is 1 week for weekly paid champions and 1 month for paid champions. For monthly paid champions, I beg your pardon. That's the provision in the written contract.
Now, I noticed, Mr. King, that the following sentence says, but first of all, you could short circuit this. Does Sandy Lane accept that the Barbados Workers Union contract, the one that you just referred us to, is part of the contractual provisions of these dismissed employees?
Yeah, the terms, the following, under the rubric conditions, the terms of this agreement are in accordance with the existing Barbados Workers Union contract. This offer is subject to positive references and the receipt of a satisfactory police certificate of character from you within 3 weeks. So it expressly, in my view, incorporates this Barbados Workers Union contract.
And does the other side acknowledge this? We should have asked them that, but I'm asking you. The case proceeded.
They did not in the magistrate's court. They did not accept that in the magistrate's court. And I don't think they accepted it in the appeal court either, but the appeal court found differently. The appeal court found that, the Court of Appeal, I beg your pardon, found that, yes, it was part and parcel of the employment contract. And
Well,
then certainly when one looks at the champion rules of the game, which my learned friend accepts as part of the contract, it refers to the collective agreement. 314.
So the individual contract, the champions rules of the game, and well, both of those documents, well, and the three documents that we're looking at. There is the individual contract, which is at page 277. There's the champion rules of the game, and then there is the Barbados Workers Union and the Hotel Association agreement. You say all three must be read together?
All three must be read together. That's our submission. There's a provision there.
And you are saying that the two agreements fetter the right to terminate by notice. That's what you're saying. If you are not saying that, then you are departing from the Court of Appeal. That's what they said. So now, what are you saying?
I don't know if that's what the Court of Appeal is saying.
I draw your attention to paragraph 38 of the Court of Appeal's judgment.
Okay.
Which is page 19 of the record of appeal.
That's not this.
If you can't find it, I'll be happy to read it for you. We are of the opinion that the termination clause relied on by the appellant cannot be viewed in isolation and must be examined within the totality of the contractual provisions, which I think you echoed. Yeah. The clause must therefore be read subject to the champion rules of the game and the detailed procedure for the treatment of matters of discipline. The result is that a fetter was imposed on the appellant's right to terminate the respondents. So I'm simply asking if that is what you also are saying, or are you saying something different? Or if you're not sure what you're saying, you can tell me that.
It's not a fetter as such, my lad. It is, yes, if you want to dismiss the worker, then you are obligated to follow this procedure. I don't know if it puts a fetter as such. It says that if you're going to, okay, if you want to dismiss, okay, but you must follow this specific procedure agreed upon.
Well, the problem, Mr. King, and this is what I'm seeking your assistance on.
Yeah.
The problem is that there is the specific contract between the parties. The specific contract says that the employer can terminate upon 1 week's notice. So you were telling us how we can, as it were, regard all 3 contractual documents. And unless you're saying that, sir, well, what are you saying about the termination provision in the specific contract? What happens to that?
You can terminate with one week's notice, provided you give the employee a fair hearing. And this is what the legislation is saying. Not the legislation, the agreement is saying. Listen, if you're going to dismiss the worker, then you must follow this procedure before you dismiss. Whether it is 1 week's notice or 1 month. What they're saying is, listen, you have to follow this procedure. You must give the employee a chance to be heard and to defend himself or herself, as the case may be.
So you don't regard it as a fetter as much as a conditionality?
It's a condition, right? It's not a fetter. That doesn't stop you from dismissing. Yes, you can dismiss, but you need to follow the procedure.
Are there built into the procedure any timelines that would ensure that those procedures can be observed within 1 week?
But no, there are no timelines to that extent. Then, to be fair, you need to extend that period of notice, to be fair. And I'm saying that the whole agreement between the union and the...
But sorry, Mr. King, not interrupt you, sir, but wouldn't that then be rewriting the contract? If you are saying that the procedure cannot be observed within a week, and the contract is saying that a week's notice is sufficient to terminate the employment, aren't those 2 positions incompatible with each other?
But not necessarily, except that the employer ought to have, if the employer had done what it had agreed to do in terms of the procedure, they would have, even before it decided to dismiss the worker, employed the process, start the process of the inquiry.
Yes, you may be right, but I think that's what Lord...
The apparatus.
I'm sorry, you may be right, but I'm thinking that's what Lord Justice Shaw had in mind when he used the word grotesque in Gunton. But yeah. Thank you.
Here we are. I think my learned friend had also raised the point of the procedure for the employees ought to have been an application to the courts for an injunction to restrain them from dismissal based on the fact that they hadn't complied with the agreed terms and conditions. But then one looks at the circumstances of the dismissal. It was almost an instant dismissal in the sense that they were called up on this fateful evening, handed these letters, told them not to report for work and to immediately return their belongings, the hotel belongings to them before they leave. So in essence, this was kind of an instant dismissal, which they would have accepted, the employees would have accepted. So I don't know how much ground they would have had to proceed to the court for an injunction to restrain the employees from their unlawful behavior.
I didn't get the impression he talked anything about an injunction. I got the impression he was saying that even after the de facto termination had occurred, it was within the competence of the affected employee to make an application to the court because the contract still subsisted de jure.
No, I don't even think that it existed de jure because the employees would have accepted the dismissal. As a dismissal, because they weren't supposed to be back onto the premises. They were supposed to leave the premises immediately. You know, as they say, that the courts are unlikely to insist on the employees retaining the employees. They insist the employers on retaining the employers. The courts are not in favor of that sort of relationship continuing, that forced relationship of employer-employee.
But you would concede, Mr. King, and this is a question, leading question, you would concede that what Sandlane did, from your perspective, was a breach of contract.
Indeed it was.
But that is not how you have framed your case. So from what you're saying, in terms of not following the procedures imported into the contract, Sandlane breached its contract with your clients. But you have not pursued a breach of contract claim. And I understand that you're saying that your clients accepted the repudiation. I understand that. So, you know, they're not pretending still to be employees of Sandlane, or they weren't around 2014. But nonetheless, the action that you have been pursuing has not been one for breach of contract. And wasn't that open? Wasn't that a possibility that you could have gone that route?
But our submission here this morning is that we have gone in the Magistrate Court for wrongful dismissal. Now, my learned friend had not in the Magistrate Court or even at the Court of Appeal, even suggested that or asked the court to consider what the definition of wrongful dismissal. And that is why we had, and I think he had raised it for the first time before Sir. And that is why I had exhibited for your consideration the definition of wrongful dismissal as set out in the Halsbury Laws of England. And if I can read it here.
Mr. King, I understood you to say that the definition of wrongful dismissal is not confined anymore to what the classical definition was, but it has become broader, as you point out, with a reference to Halsbury. Is that what you are saying? It cannot be limited.
That's what I'm saying.
Yes. And
it can't be limited, as another friend has stated.
Yes, and I also
and that is where we got into the argument of examining the Gunton case.
Yes, and I also understood you to say that, to put it in those words, this is a breach of contract resulting in a wrongful dismissal. In the broader definition that you that you have referred us to. Is that correct?
Yes, that is correct. And of some interest to refer you to the again to the workers' union contract with the employers union. The appendix 3 of the protocol, where it is. What's interesting? If you want to give me one moment, this. Page 369 of the record. Which deals with termination of employment as well. And the issue of the job security. The parties in the agreement accept that job security is an inherent element of the labor contract. The parties, therefore,
What document is this, Mr. King?
The union contract, page.
I see.
3.
Okay, I know. I have the page. 369. Convention 158.
70. Yes, my lord. 158. Yeah, the protocol on job security. This is an appendix to the contract. So the whole thing is to inject a sense of fairness in the absence of, at the time, in the absence of legislation. The parties had sort of agreed to be fair in their conduct of business as between employer and employee. In a sense, they had established their own laws in dealing with the issue of employment as between the group of employers and the Barbados Workers Union, of which the 3 respondents were members.
Mr. King.
Yes.
Clearly, the employer in this case had certain concerns, allegations. You are saying, well, that should not have led to this termination with notice of one week notice.
Yes.
So, in your view, given the totality of these legal instruments, what should have been done by the hotel, by the employer? How should they have proceeded? Send a letter by saying, okay, these are the allegations, these are our concerns, and then what would be the next step?
And inform the employee of their intentions as to what they intend to do as a result of this, if proven what they will do. And that will have given the employees an opportunity to defend themselves.
So they should have said, well, these are the allegations that we have, and we intend on the basis of these allegations to terminate your contract.
Yes.
And then the reaction could have been of the employees, okay, we want to fight this in accordance with the procedures that are there.
Yes, indeed. Yes.
And then if in the end the allegations were proved true, it is only then that you say, then they could terminate the contract with the week notice.
Indeed.
Okay.
Sorry, does the obverse also apply, Mr. King? If the allegations prove not to have been made out, is it then the case that the employer could not terminate?
They could not terminate. Because according to the...
in effect, you're saying that the employee employer could only terminate with cause.
Indeed.
Okay.
That's what I'm saying, and that's my submission. And that is what they have agreed to.
And Mr. King, if we are with you on that, what do you say this court should do? What are you asking for?
We're asking for damages for wrongful dismissal. We're saying that the dismissal was wrongful in the sense that they have not complied with the procedure that has been set up.
And Mr. King, how are those damages to be worked out? What are you asking for precisely?
In accordance with Section 45, I think, of the Severance Payment Act.
Mr. King?
Yes.
Can I take you back to the Halsbury definition of wrongful dismissal that you alluded to earlier?
Yes. Submissions.
I think it's at page 700 of the record.
Yes, I'm with you.
Right. So I imagine you're not relying on the first paragraph.
Wrongful dismissals and breach of regular positions of the contract of employment relating to the expiration of the term for which the employee is engaged. To entitle the employee to sue for damages, two conditions must normally be fulfilled. The employee must have been engaged or experienced, yes. This have been without sufficient cause to permit the employer to dismiss him summarily.
Right. So I imagine you're not relying on that because clearly under the express term of the contract, Sandy Lane had acted pursuant or in accordance with that clause allowing for termination by giving 1 week's notice. But I think paragraph 2 could support you.
Yes, in addition, there may be cases where the contract employment limits the grounds on which the employee may be dismissed or makes dismissal subject to a contractual condition of observing a particular procedure,
Yes.
which is our case here now.
That's exactly your case. So you would have to find then something in the contract which makes dismissal subject to observing that disciplinary procedure you speak of. Yes, but the trouble is I can't seem to find anything in the contract which does that. Perhaps we are re-arguing a point you've made before, but I don't see anything in this contract that makes dismissal subject to observing that particular procedure. I mean, I see the opposite, that you give 1 week's notice, but I don't see that procedure. And the cases which are cited to support that in Halsbury, starting with Jones, I believe it is. Do you have anything from Jones against Lee and Gilding, 1980, that could support that proposition that you're relying on in Halsbury?
I think I looked at John. We looked at Jones. We looked at Gunton. And the CXC.
Yes. Well, I think we have spent a long time on Gunton, but what about that CXC case? Is it Hackett you're referring to? Is that Hackett and CXC?
Okay. How much? 675. You didn't see anything in this area. Head note says. The employee in this case was dismissed without a hearing, actually, and I think they relied on Gunton in finding it in their favor.
Yes, you mean that's a Hackett case you're thinking of?
Yes.
Yes. I'm not 100% clear on Hackett. I need to read it again. Was there an issue of the registrar there resigning?
Mm-hmm.
But I don't want to detain you too long, Mr. King. I will myself have a look at Hackett because you rely on it, obviously, and I need to advise myself a bit more about it. So I don't want to detain you too much longer, but thank you for the assistance.
You're on mute, Mr. King. So you haven't been hearing you for the last minute or two.
Oh, I'm sorry about that. We will contend that it is somewhat disingenuous of the appellants at this stage that they are not bound by the terms of the contract. Having introduced them into the terms of the agreement, then it makes a mockery of the entire system of collective agreements, and for the employer only to pay the service to it and claim not to be governed by it. And this is why we introduced this concept of trust and confidence as itself being also a breach of contract, because as an employee, they expect you to behave in a way that you said you would behave.
Yes. From your experience of the operation of, I'm sorry, I don't know if the president fell out.
I beg your pardon, I didn't get that.
I think we're waiting for the re-entry of the president. He might have fallen off.
I'm back.
Okay. Yes. No. No. I was wondering aloud with you on the question of using your experience, distinct service in this field. Can you assure us that the employer, under the current regime, the statutory regime, cannot opt out of the legislative arrangement? Can the employer do that?
No, they can't.
Okay, so these kinds of cases,
for them to opt out.
right? So this kind of a case then is of a, what can I say, a dwindling category, and we're not likely to have these kinds of cases in the future. Is that a fair assessment?
I would think so, sir. It is because of the absence of this current legislation,
yes,
that the Barbados Workers Union, the unions, were forced into going into this type of agreement with employers.
Yes.
And I think it is unlikely that this sort of thing would happen again.
Okay. And you have confirmed that employers cannot opt out. So as I said, this would represent, based on that, one of a diminishing number of cases coming before the courts. Yeah. Thank you.
I don't know if my learned friend has any more in the pipeline.
But there is a definite expiry date for these kinds of cases. That's what I'm trying to get at. You can't have more in the future coming up. Okay.
Mr. King, would you agree, and I think I'd ask Mr. Kissoon this as well, that the legal questions in this case really boil down to, one, what is the quote-unquote contract of employment that one has to interpret, whether that contract of employment is an intertextual interpretation of all three documents, or whether it only isolates a single one of the three. So that first has to be determined. And secondly, if the contract of employment is the intertextual interpretation of all three documents, what is the effect on the termination provision in a single one of those three documents, on the, what is the effect of that on the relationship between the employer and the employee?
But I think the whole thing boils down to what is reasonable in terms of the relationship. And I don't think that there is that much of a conflict. I think there is a provision in the workers' union contract, which deals with that. In effect, what it says is this much. I'm looking here at the union contract, which is at page 340 of the record. Work rules. Every hotel, apartment, guest house, subject to this agreement, shall, after consultation with the union, draw up a list of rules and regulations to guide the work relations at the establishment. Nothing in the said work rules and regulations shall be repugnant to the letter or spirit of this agreement, neither shall it infringe upon the constitutional right of any employee. Every employee shall be furnished with a copy of the work rules and regulations of the establishment in which he or she is employed. So to some extent, I would think that in trying to interpret the rules, it is important to be reasonable and sensible.
Okay, I got you.
If you want to enjoy a harmonious relationship between the employer and the employee.
I think it's a different way of saying the same thing. But that's fine. I understand you. Okay, is there anything further that you wish to tell us that you haven't said before?
No, I don't think that there's anything else I need to add. I've covered most of what I wanted to say in the submissions, written submissions.
Yes. Okay. Thank you. Mr. Kissoon, do you have any reply to make?
Please, Mr. President, I'll be very brief. Just highlight probably 3 points, and I'll do it in reverse order with your leave. Yeah, just on the point of the cases coming before the court in the future, any court, just wanted to highlight that under the ERA, there's only a certain person or type of person who can qualify for the conditions of the ERA. So there will be reasons for employees to bring wrongful dismissal suits in the future who may not qualify to bring the matter before the tribunal. So I just wanted to make that point so that this court's view on the matter won't be purely academic. that was one point. The second point was in relation to Hackett, and I'll be brief. We didn't find, and still don't find, that Hackett is helpful to the analysis for two reasons. Essentially, the fact circumstances are obviously different, but at R703 into 704, what we'll highlight is that this was a case that dealt with the adequacy of the notice, and the court there formed the view that the notice was shorter. So
you've gone on mute, Mr. Kissoon.
Apologies. Thank you, Mr. President. I'm saying this is not a case that we think assists in the determination of the issue before the court to date. Hackett is not, in our view, helpful for that.
I think, Mr. Kissoon, there is a quotation from Hackett to the effect that if it, I presume CXC, if
Yes.
it wished to terminate her employment without taking disciplinary proceedings against her in accordance with the staff rules, it was obliged to give her 3 months notice or payment in lieu. So,
or payment in lieu. That's the part that we do find helpful, in the sense that that is in line with what we are saying and the definition of wrongful dismissal. So in that sense, it accords and in fact supports the appellant's case, but we don't find it helpful for the respondent's case. In essence, I'm obliged to the court. I wanted to just turn back briefly to Halsbury, and the court earlier had, I thought I understood the court to suggest that the Halsbury, the definition of wrongful dismissal had become broader, but we want to just make certain that that position isn't the takeaway, because our view is quite different. If we look at page 700 of the record, and we look at the meaning of wrongful dismissal, what we'll see, and we've addressed this in our submissions, but I'll re-highlight, that two conditions which must normally be fulfilled are conjunctive. It's not an either or. So if we look at 700, it says the employee must have been engaged for a fixed period and terminated without the requisite notice, and must have been without sufficient cause. So it being without sufficient cause by itself wouldn't in fact be the broadening of wrongful dismissal if there had been the requisite notice or payment in lieu, it being necessarily conjunctive.
No, I understood Mr. King to say he was not relying on that.
Yes,
he was relying on the second paragraph, which purports to expand, in his view, the definition of wrongful dismissal.
And the argument that we submit is that it is a conjunctive approach, so that you must first not have given the requisite notice, and the dismissal.
No, I think you're not on the same wavelength, Mr. Kissoon.
No, I apologize, perhaps.
Paragraph goes on, in addition. So you're not dealing with 1 and 2.
Oh,
so
the last part.
In addition.
Yes.
Yes, yeah, my apologies. And of course, that's where we get the extracts and the cases that we were discussing as well. But yeah, I'm obliged to the court. As I said, I thought it understood that that's where the extension has been. The last point that I would raise is just a collective of 3 takeaway things which I see merging from reliance on the BWU agreement or the champion rules of the game. And our submissions deal with the BWU agreement by way of governing or in accordance with and so on. But firstly, where the employer must follow the procedures for grievance, what would emerge is that the employee is entitled to the contractual remedy. So I'm making the point, we said it earlier, that what is the remedy that the BWU agreement affords? It is, as it is framed, the fact that the decision is set aside. But that still doesn't entitle the employee to make and sustain a claim for wrongful dismissal for the reasons that we advanced earlier, because it has a specific meaning and definition. So there is a contractual right, if it is that the BWU agreement is found to be a part of the employee's overall agreement, the interplay between the 3 documents, as Mr. President noted just a moment ago. However, what is the outcome of that, even if it's found to be relevant? It is the remedy under the contract, and the remedy is for the decision to be set aside. There isn't the remedy of that specific cause of action, as Chief Justice Simmons says, which came from the common law of wrongful dismissal. And that would be the extent of my reply, Your Honor.
All right, thank you very much, Mr. Kissoon and Mr. King. Naturally, we will take time for our decision, and the registrar will let you know in due course. Madam Acting Registrar, can you please close the proceedings?
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath Lee. Thank you, Mr. Justice Barrow. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.